and Carrie, that's a great segue to my next question, which is timing. When's a good time? Like, when's a good time to file the motion? 1 month after the final order? I always tell my clients, you mean at least wait till the ink is dry,
Right. So,
unless it's something substantial. But kind of give your thoughts on timing wise.
so, obviously, if somebody comes back 2 years after the final order, right, and the new facts, the change is something that in any event would be significant and sufficient for a change. 2 years is certainly enough, right? When people come to me immediately after a final order, a few weeks, a month, what I always tell them is this: unless your child is in danger, I always say wait at least 6 months. Because in my experience, unless the child's in danger, the court is going to say, why are you here? You were just here. What do you mean something changed? How could something have changed? How did you not know about this? We were, and so if it's something like, for instance, the grades are slipping, the other parent's not getting the child to school on time. The other parent missed a volleyball game, a therapist appointment, a well check, these sorts of things. First of all, there's a lot of adjusting that's going to happen. After these final orders, you're going to have parents learning to co-parent. You're going to have parents learning to parent. I mean, you're going to have parents who've never parented their children any significant period of time because there was a relationship where you had a primary caregiver and the other parent didn't have a lot of involvement. And so there's a lot of adjustment that occurs. And in that adjustment period, things will happen with these children, unfortunately, like being late for school, not having homework done, missing events, falling down and scraping their knees more than they ever did before. And so I always tell people, wait at least 6 months. If it's these sorts of small things that are probably attributable to that adjustment period, again, unless your child's in danger.
I just worry a little bit, Carrie, that the people listening to this are going to say, oh, I got a 6-month magic window. Be very careful with any specific time period. There's this quote that will be thrown in a litigant's face, and we've all seen it multiple times. We're not going to allow a litigant to file immediate, repetitive serial motions until the right circumstances or the right judge allows them to achieve a different result based on essentially the same facts. So we're back to what constitutes a change of circumstance, what constitutes a material change. And again, the only thing I would suggest to people before you pull the trigger, at least consult with a family law specialist, because again, it may just be a matter of know it when you see it, but when you've seen 10,000 of them, you're a little bit better about discerning what a judge is likely to believe is and isn't significant.
Can I weigh in on that one also?
Yes, please, Michael.
Okay. I would agree. I understand what Carrie is saying, but the time frame things jumped out at me too, because I worry about this, have the same concerns. So this is what I always tell my clients. To modify custody, it's going to come about in two ways. It's going to become either through a series of things that accumulate over time, or one large event, or maybe one or two medium-sized events. Those events, you're going to know when you see them, which we've said a few times now. They've been arrested, they're in jail, they're in rehab, they've fled, they're indicted, whatever, right? Those ones we're going to know right away. We can move on these right now. We don't need to do any more fact finding here. We're ready to go. The other ones require, my advice to those clients are document. If there's deviations in timeshare going on, another party not exercising their time, which is one of the major components that people seek timeshare or custody modifications for. My advice to people to do that is to document, and again, not to give a time frame, but I usually say like a year time period to show some sort of historical time frame of custody, but it's something that you don't want to do too soon. And here's the thing we haven't talked about today is why you don't want to file a motion too soon. And the reason is credibility. If you start filing motions too soon and you don't meet that threshold that's set at that gatekeeper hearing and you start getting denied, that's going to become a pattern. And every time you seek modification thereafter, your chances dwindle and dwindle and dwindle. And you start to get looked at, as Marshall said, as a serial litigator trying to file the same thing, repetitive motions to get a different result. So that's kind of my viewpoint on what I advise my clients to do and the types of things to look for and the timeframes.
That's all great advice and great examples. And again, I think articulates the difficulties of our jobs when people come to consult with us and analyzing a case. When is the right time? What evidence do you need? I say document, document, document all the time as well. And sometimes what if you've waited too long and if you acquiesce to the behavior and if you allowed it to continue, is the judge going to hold that against you? I've seen that happen as well. So there's it's definitely a tough area to navigate, and that's, you know, why we're here to help and why we're here to do this.